My name is Merida Wilda Colon. I am the director of the Stockton Center for Community Engagement, and I am very proud and pleased to be co-hosting this foreclosure information session with the Superior Court of New Jersey. I have to thank Kathleen Obringer, Sarah Chavez, Sandra Rodriguez for their support. This would not have happened to have our great panelists here had it not been because of work we do with the vicinage of the Superior Court. We will begin with Irene Commandes. She is the Ombudsman from the Office of the Superior Court Clerk. We have Catherine M. Gilbertson-Shable. She's the Assistant Chief Office of Foreclosure. George Cohn is the Division Manager. And Mitchell Maskovitz, Senior Attorney. So we hope to see our Chair Frank Ballas arrive at any point. So without any more delays, I would like you to begin your presentation. Thank you.
Thank you.
Thank you.
Can everyone hear us? Okay, good. So the reason that Catherine and I are here is we are from the Superior Court Clerk's Office. I'm the Ombudsman at the Clerk's Office. Catherine is the Assistant Chief. The way that foreclosure is structured in New Jersey is that all documents in foreclosure cases are centrally filed at the Superior Court Clerk's Office, regardless of where the property that may be involved in the foreclosure process is located. So whether you're in Bergen or Atlantic, all of your paperwork for processing purposes is going to be sent to Trenton, not to your local courthouses. In that way, foreclosure is different from other legal processes, and that is why Catherine and I are here, because we have been affiliated and are involved with the processing and the review of foreclosure cases. So we come with a unique perspective. But just to give a little bit of information, foreclosure is a specific legal process in which the lender of title is looking to basically get back possession of whatever the asset was. In a foreclosure case, it is the property. That's what was used to secure the loan in the first place. Foreclosure actions are what we have in New Jersey. They're considered chancery actions, not law division, so they have an F docket number. And the difference is in a chancery action, the person who's filing the claim isn't necessarily looking to get money. What they're looking to get is the property. They're not looking for cash from you. They're looking for the property so that they can subsequently sell it and get back whatever monies they feel that they are owed. So if you have a foreclosure case, it's going to have an F in front of it, in front of what we call the docket number. No two docket numbers in the state are going to be the same. So in the event that you find yourself involved in a foreclosure or any other action, and you call and you look for information, that's the number that you would want to be able to provide to the person that you're going to talk to on the phone. So if you ever called over to the clerk's office and wanted to know about your foreclosure case, we would ask you for your docket number, and it would have the F in front of it. As I said, all foreclosure filings in New Jersey are done in Trenton. Our address is 25 Market Street in Trenton, New Jersey. If you inadvertently send your paperwork to your local courthouse, chances are they're going to send it back to you with instructions to send it to Trenton. So it's just easier on the front end to send everything to us directly. So foreclosure actions in New Jersey can be filed in the following types of cases, and we've listed them. By and large, the largest is the commercial and the residential mortgage foreclosure, but we can have what we call tax foreclosures, and those come from tax liens. Condominiums and homeowners associations can also file foreclosure actions in this case. They are liens against association dues and whatnot. Timeshares can go into foreclosure, and they are, is this the OOPS foreclosure, Catherine, the strict foreclosure?
The strict foreclosure is what we call the oopsie foreclosure. It usually happens after a foreclosure has completed and a plaintiff has failed to notice a proper party, which would be anyone who has a title lien interest in the property, which might mean a judgment holder, a second mortgage who was inadvertently not included. And it's so it's a foreclosure that's filed after the foreclosure, and it's specific to that one defendant. It's not anything that a resident would actually usually be involved in. And then, of course, there are what we call optional foreclosures, and the most important thing about optional foreclosures that the public should know is that they do not end in a sheriff's sale. If a mortgage holder has filed an optional foreclosure, the issuance of a final judgment is a deed. and it transfers the property immediately to the foreclosing plaintiff. Optional foreclosures are very rare. They're difficult for the plaintiffs to process, and it's a very rare case. But in the same vein, if you are involved in what we call a tax foreclosure because there was failure to pay taxes and a tax sale certificate issued, that also does not end in a sheriff's sale. That results in a final judgment, which is also a deed, which means when a foreclosing tax lien holder gets a final judgment, they can obtain a writ of possession immediately, which does come as a surprise to a lot of people who are involved in tax foreclosures. When filing a complaint, the biggest question we get is who can be a defendant. Anyone who signed the mortgage, the note, or the owners. Any subordinate mortgage holders are mortgagees who gave mortgages after the first mortgage, home equity lines, anything like that. Subordinate judgment lien holders in New Jersey, anyone who obtains a judgment against you in any kind of action, special civil law division, that judgment is docketed and then becomes a lien on any property owned by that defendant in the state of New Jersey. Tenants and occupants are very often named as defendants. They are not what we call necessary parties, but very often they're named to put them on notice that a foreclosure is happening. If there is a condominium association, if a mortgage company or a bank is foreclosing a condominium, they will often name the condominium, again, for several reasons, one of which is to put them on notice. And then there's anyone listed in the chain of title. So if the property gets deeded after the mortgage, or anyone puts on what's called a lis pendens or some sort of lien interest, they will also be named in a foreclosure. Also, heirs to an estate are named, and this is also something that causes some confusion in the general public. The estate is not a proper party for legal reasons, but the heirs are a proper party, and that's because upon the death of someone, the heirs have an interest in the property. Whether they wanted it or not, they become interested parties. Who cannot be a defendant in a foreclosure? Anybody who's prior to the mortgage interest. So lien holders, mortgage holders. The biggest one, of course, is our municipal tax lien holders. Taxes are supreme, and they have a lien, whether it comes after or before the mortgage. They are always first, and they are not named by mortgagees in foreclosures.
So as I said, once a bank or a mortgage lender files a foreclosure action, it is going to receive a docket number. That docket number is going to start with the letter F. And then the next step is that complaint for foreclosure is going to be served on the defendants in the case. And Catherine just went through the list of who can and cannot be a defendant. But, obviously, in every case, there is going to be someone who owns the property, and that person is going to have to be served. And there are multiple ways in which a person can be served, and service often causes a little bit of confusion. The gold standard for service in New Jersey is what we call personal service, meaning somebody physically comes either to your door or to your person, and they hand you the foreclosure complaint. They have personally served you. Oftentimes, it could be a process server, but not always. That is service of the complaint. You are now on notice that a complaint for foreclosure has been filed on this property and that you have some sort of an interest and have been named in the complaint. There's also an acknowledgement of service, and that generally is in the situation where you may have an attorney, they're going to serve the attorney is going to acknowledge service for you. There's also mailed service. In instances, they will be able to mail you a copy of the complaint, and that will be good service. And the last one is published service, and this where it gets a little bit tricky here. If they're not able to serve you, if you are, and this is a general use, this isn't in a specific context, but if you are away or they can't find you at the house or you're just, you're trying to avoid service, what will happen is that they will publish that they have filed a complaint in the paper, and that will be considered good service. It's not, hopefully it's a paper local to you. I don't know how many, I think the Star Ledger is the only statewide paper, but it could be in, if it's in Trenton, it could be the Trentonian. Up north, it could be the Bergen record. So that's always something to be cognizant of. Generally, everybody's going to start with personal service because that's the most accepted and that's the best way. So that's obviously the preferred method. But in the event that someone has, let's say, abandoned the property, it's not going to be possible to actually locate that individual. Eventually, we're going to wind up with service by what we call publication. And that, in a foreclosure case, is considered good service. So the next slide is just to give you a simple overview of a foreclosure case. And it's a pretty linear process. So you're going to have your complaint. Your complaint is going to be filed. If it moves in the most expeditious of ways, there's going to be either a lack of a response by the defendants in the case, or there's going to be what we consider a non-contesting response. That happens, then the defendants get placed into what we call default, meaning they have not contested or disputed the foreclosure, and then the foreclosure goes into, or the property goes into what we call judgment, whereas there's a judgment and a writ that is issued, and oftentimes there's a share of sale. So that's a global view of the process. All court cases work a little bit differently, but I believe there's value in understanding the process from beginning to end, because then you can understand what the next logical step is in a foreclosure case. But if you are served with a complaint in a foreclosure case, you have, under the law, 35 days to file an answer to that foreclosure. So for example, if somebody comes to you on the first of the month and they serve you with a complaint in foreclosure, you have 35 days from the date that you receive that document in order to file an answer. Now, the Superior Court Clerk's Office has actually created packets, and I do have something to distribute later which gives you the link to where they are, but we have what's called self-help packets. So in the event you are looking to file an answer to a foreclosure, that's actually a link that you can click on, and I'll provide it here, and we have a form packet that will assist people in preparing an answer to a foreclosure complaint. The facts of a foreclosure case are specific to you. No two cases are the same, so no two answers will be the same, but form-wise, we do have documents available to help individuals structure their answers. If a party does not file an answer, you get put into what's called default, meaning it's recorded in your case that you have not filed an answer. So the case is not contested, which means that the plaintiff can then move forward to take the next step. If you do choose to file an answer, as with all things, there is a cost associated. It is $175 to file an answer, and I make mention of that because oftentimes that can be a reason why an answer is not filed. It lacks the appropriate fee. So it's worth noting that if you are looking to file an answer, the cost is $175. If your answer includes something other than a response to the complaint, meaning you are going to assert claims of your own, or you're going to file your own action against someone else involved in the foreclosure, and you put that in as part of your answer, it's going to be $250. All answers have to include certain information in order for us to process it. So one is the filing fee, and the other one is what's called a case information statement, which is literally one sheet that gives us over at the courthouse all the relevant information on your case. And actually, I've included a link to that as well, because the absence of that document could be a reason that an answer isn't filed. So we really do make an effort to give you as much information on the procedure as possible, because nobody wants their paperwork returned for a procedural issue. I mean, that's a simple enough thing to get around. Anybody who has any questions can obviously call over to the clerk's office and get somebody on the phone who can either direct them to these forms or help them with the process.
The most important thing you should realize, though, is that if you fail to answer within those 35 days and the plaintiff has put the defendant in default, you would have to file a motion to vacate that default prior to being able to file your answer. So if you are unsure as to what your status is, you can always call the clerk's office and find out if a plaintiff has entered a default in your matter.
So in New Jersey, the courts do offer a mediation program, and I make mention of this because I think the program has a lot of value, but there are also some parameters around mediation. The most significant is if you want to apply for mediation. And this is court-sponsored mediation, meaning we would send you to mediation, you would go to your local courthouse, a representative from the bank and yourselves with a mediator provided by the courts would all sit down together and try to work out a modification to try and work through either some other payment plan or some other resolution to basically dispose of the foreclosure that way. Some solution other than the property going to sheriff's sale. Mediation must be requested within 60 days of service of the complaint. If you do not request it within 60 days, you must make a motion for a judge to allow you to participate in the program. This is crucial. We get a lot of requests for mediation by individuals who are maybe 100, 150 days in. If you're not within 60 days, you're going to need to make a motion to go to a judge. But if you are within that 60-day window or you have an order from a judge, you can apply for mediation. You would send your application to the clerk's office. The only thing with mediation is you have to be, with a property in foreclosure, has to be your primary residence. Everybody on the note has to want to participate in mediation.
And just for clarification, the note is different than the mortgage. You may have signed the mortgage, but not signed the note. If you haven't signed the note, then your signature is not required for mediation. If you signed the note and didn't sign the mortgage, your signature is required for mediation.
Yeah. So these are the requirements. I put them up behind just so everybody can see. It becomes relevant because, for example, you purchase a home with your husband, you both sign the note. You subsequently get a divorce. The house goes into foreclosure. You want to apply for mediation. Your husband won't sign off on it. You can't go to mediation. You need to get a judge to say you can go to mediation. And so that's a crucial component because oftentimes individuals, they get divorced, they think it's part of the divorce, everything is resolved, I can proceed solo. That may not always be the case. So having this information up front is good. There's no fee to participate in the mediation process. As long as it's your primary residence, you're within the time frame. Everybody who signed off on the note wants to participate, and you can't be in bankruptcy. That's the other thing. You're not allowed to be in bankruptcy. Other than that, you can make a mediation application, it'll be accepted, and the case will go through to the county. Mediation won't stop your foreclosure, so you should still file an answer and proceed with the foreclosure, but it is a valuable tool for individuals who are looking for some sort of an alternative resolution to the foreclosure case.
Also, just to note, you do not have to file an answer to participate in mediation. So if you're not contesting the foreclosure, then you can still participate in mediation. There's a lot of motion practice in foreclosure. There are a number of things that happen between the time the complaint is filed and the default or the final judgment. Any party can file a motion in a case seeking whatever relief they want. All the motions, as Irene had said in the beginning, are filed in Trenton. That does not mean that they are heard in Trenton, but they can be filed. Everything must be filed in Trenton. Motions for review by the Office of Foreclosure are, that form is located at the link right up there. As a defendant, your motions are not for the Office of Foreclosure. They are immediately considered contesting, and therefore they should always be forwarded to the vicinage judge. So if you are a defendant in a foreclosure, you always want the motion to the vicinage judge. And that does confuse people because they think there are certain things that the Office of Foreclosure does, but the Office of Foreclosure only handles non-contesting matters, and if there is a defendant litigating the case, that is a contested matter no matter what the motion is. So they should always go to the vicinage judge.
So for purposes of a defendant in a foreclosure case, let's say you want to file one of the motions I brought up. You want to file a motion to participate in mediation. Okay, you want to file a motion to vacate a default, so you can file an answer. The second form, and I'll pass these out, that's the form you want to use. Okay, so make a note of that. You would never use the one above it. You always want to file a motion to be heard by the judge in the county.
There are also two types of opposition that are filed. There are oppositions to motions before the Office of Foreclosure. Plaintiffs make motions before the Office of Foreclosure. Those oppositions, that form is right there, and you can get that online. Oppositions, if a plaintiff or a defendant makes a motion to a vicinage judge and you want to respond to that motion, those oppositions, that form is also there. So there are two types of motions: motions before the Office of Foreclosure, motions before a vicinage judge. If a plaintiff has filed a motion and you want to file an opposition, you do make your opposition to the Office of Foreclosure. We then send the whole package out to the judge for review.
So the,
To clarify, that's completely opposite of the last brief for filing
So the way to think about it is this: a motion is a proactive action by you. You are making a motion. For example, I want to make a motion for the judge to declare that the sky is purple, okay? That is your proactive motion. You are asking for the courts to give you something that we call it relief. You're asking for relief. If you make a motion, the other party to your case has a right to file opposition. They don't want the sky declared purple. They think blue is a fine color. They're going to file an opposition to your motion. On the other side, should the other party to your case file a motion, you then have a right to oppose that motion. It's a way of bringing your requests before a judge, and both sides have an opportunity to present their information and bring it all before the judge. Whether you file a motion or an opposition just depends on the point in your case. A motion means you made the first move, you made the motion. An opposition means you're responding to someone else's motion. That's the difference between the two types of documents.
And as a defendant, your motions, your proactive actions always go before a vicinage judge. The plaintiff, in a non-contesting matter, many of their motions go before the Office of Foreclosure. But just because they're making a motion to the Office of Foreclosure doesn't mean you, as the defendant, can't file opposition. You are allowed to react.
In the
And so
event,
then you would send it to the Office of Foreclosure, and the whole thing then is transferred to the judge.
if you need clarification before you take a step in filing a motion, you can always call over to the clerk's office. And the reason that's important is there's a $50 fee associated with filing a motion. So you want to make sure that you're using the right form when you go and you file the motion. That's what we're there for. Give us a call. We'll point you in the right direction.
The last step of a foreclosure is the final judgment, in which the plaintiff will ask for the court to set an amount due, which is the amount they seek to recover from the property. They are also then issued a writ of execution at that time. The writ of execution is presented to the sheriff, who then will schedule a sheriff's sale. Without that writ of execution, the sheriff can't schedule a sheriff's sale. If you are served with an application for final judgment, you may file opposition to that also. And there are oppositions to, there is a form for that also. If it is the first time you are appearing in the case, everything has gone to the point of where it's at final judgment and you file opposition, it is $175. If you have been litigating the case and you filed an answer, you filed motions, and we are at final judgment, there is no fee for an opposition. So it's only $175 if you have never appeared in the case before.
So once final judgment is filed and gets resolved, and the plaintiff gets what's called a final judgment and a writ of execution, the final judgment will contain the amount, which is the total amount that has been determined to be due and owing on the original mortgage. They also get a writ of execution. And what that allows them to do is it allows them to go to the sheriff. They present the writ of execution to the sheriff, and they ask the sheriff to basically execute on the judgment. And the way that that happens is the sheriff schedules what's called a sheriff's sale. Sheriff's sale is exactly what it sounds like. The sheriff is effectively going to auction off the property so that they can get back whatever money they say has been determined is due on the mortgage. Now, sheriff's sales are not scheduled by the clerk's office. You will receive notice of the sheriff's sale. Oftentimes, you will only get about 10 days' notice of the sheriff's sale. We don't have that calendar when things are scheduled. You would have to contact your local sheriff for that. However, in New Jersey, under the statute, and I have it there at the end, you are entitled to ask the sheriff to what we call adjourn or postpone your sale twice. After that, if you are trying to put off the sheriff's sale, you need to file a motion to do what's called stay the sheriff's sale. It won't terminate it in its entirety, but it will put it off for a certain amount of time. That is a motion like any other, and there's a fee associated with that, but we have a dedicated form for motions to stay sheriff's sale. Be advised, though, that you have to exhaust your adjournments before you try to file a motion. There's no sense in filing a motion, paying $50, only to have it denied because you haven't used your 2 adjournments. Just be mindful of that. If a sale goes forward and the property is sold, what will happen is that the person who purchased the property will come back to the Office of Foreclosure and they will ask for what is called a writ of possession. A writ of possession is it's different than a writ of execution since we've already moved forward on the judgment. A writ of possession is their request that we issue a document to allow the sheriff to go and take actual possession of the property. We do have packets for writs of possession to the extent that someone is purchased a property but they're not familiar with how to obtain a writ of possession. We do have form packets for writs of possession. Just as a quick caveat, writs of possession are only going to be issued for purposes of evicting the owner of a property. If you are a tenant in the property or you're some other type of person, you wouldn't come to the Office of Foreclosure to get a writ of possession. You'd likely have to resolve your matter either in landlord-tenant court or file some sort of an ejectment action. Just because you're a tenant and the property that you live in is foreclosed upon, that doesn't automatically mean that you are evicted from the property. If you're paying rent and doing everything you're supposed to do as a tenant, you still have a right to stay in that property provided you have a lease and all of that. So we would not be involved with that type of action.
There is, the last motion that's usually involved in a foreclosure can be a surplus money motion, and that's if the property sells for more than the judgment amount or more than the plaintiff's bid amount. The former owner or anyone who claims to have a right to the money must file a motion to obtain the funds. So if you were the owner of the property and it sold for more, you could make a motion for those funds. A judgment lien holder, a second mortgagee, someone who obtained a judgment after the foreclosure, any of those parties are people who make motions for surplus money. We also have that form available online for you. Last one, bankruptcy.
So bankruptcy, we put this in here because it oftentimes causes confusion. Bankruptcy will do what's called, it will stay foreclosure. When a bankruptcy case is filed, the bankruptcy court takes priority over all other things. So if you're involved in a foreclosure and bankruptcy is filed, that foreclosure case will stop until the bankruptcy is resolved. However, bankruptcy does not eliminate the foreclosure. The foreclosure will continue once the bankruptcy is resolved.
Unless, of course, you resolve the debt that's owed with the bank in the foreclosure, which can happen in a Chapter 13, and you can reorganize and resolve that, and then the foreclosure could be dismissed by the plaintiff. But if that doesn't happen and you default in the bankruptcy, then the plaintiff will move before the bankruptcy court to lift the stay and come back to us.
Mm-hmm. The only other thing is the courts don't communicate the way we would sometimes like. Bankruptcy court is different than the court that we're located in. So in the event that you are involved in a foreclosure, you have to let us know that you're involved in a foreclosure. The Office of Foreclosure won't know to stay a foreclosure case and not do anything further with it or accept any more filings unless we are affirmatively told that the case is in foreclosure.
In bankruptcy.
Or in bankruptcy, excuse me. Unless we're told it's in bankruptcy, we'll continue to process documents on that case. And the last thing, and we included it in here because we do provide a form, is a form for fee waiver. Oftentimes, individuals do make an application to have their fees waived. We have a form for that. It's located there. You would have to provide certain information, and you would submit that to a judge. If a judge makes a determination that fees don't need to be paid in this case, then we would not require you to pay any of the filing fees.
And just as further information, if you do obtain a fee waiver, you should include it in every filing that you have. So you should include a copy every time you file a motion or an opposition, anything that you file, you should include that fee waiver.
That's all we have for you.
Thank you.
Thank you.
Hi, everybody. I'm George Cohn. I'm the Civil and General Equity Division Manager for the Atlantic and Cape May listenage in Superior Court. I'm going to talk a little bit about what happens when foreclosure actions come to the local courthouse. As we've detailed before, most of the activity goes on in the Superior Court clerk's office, and as was noted, all the papers really do need to be filed there. One of the things that they do that's relatively unique in any court system is they will, upon receipt of an answer, if you remember that if you've been served with a complaint, you have 35 days in which to file a written form of an answer, is they will actually look through it for sufficiency. Is there actually an affirmative defense there? And if they find that it is an affirmative defense, that case will then get transferred to the vicinage or the county where the property exists for eventual resolution. So at that point, we have joinder. We have both parties that are trying to accomplish something. The plaintiffs in this case are trying to reestablish or get possession back of the subject property. And the defendants are trying to stop that. So what happens when there's an answer that's filed that's sufficient is the case will then get transferred to the local vicinage. What we do is typically upon receipt is we schedule, the first thing is a management conference. And what this is a conference in front of a judge with both parties. Typically, we'll do it by telephone. There are some exceptions where the judge may require an appearance, but typically it's a telephone conference where the judge will make an assessment of how complex the matter is and how much time would be required in order to get the case ready for perhaps an eventual trial, but some resolution. What the judge is trying to do is get it to resolution. Quite frankly, we're held accountable for the timeliness of the resolution of these things. And part of my job is to constantly prod cases forward to get them toward resolution. We're working under a one-year time frame, which is the standard to get these done. So the judge will spend some time with the parties asking about what the nature of the foreclosure action is. As you just heard, there's a number of different kinds, what the nature of the defenses are, and will craft a management order where the parties will engage in an exchange of information. In New Jersey, we basically litigate with open book. I ask you for anything, and you have an obligation, within reason, to respond to that completely. There's a period of fact-finding where each party is going to be asking questions of the other to find out what their case, or at least their side of the case, is about, so that they can kind of reach to where they're eventually going to resolve this issue. And we try to do that within about 9 months or so to get this going. So in case something does go awry, there is a little bit of extra time. Typically, the kinds of things that are engaged in the discovery period would be forms of interrogatories, which would maybe a series of questions that would be required to be answered. Sometimes they may ask for a deposition where there would be live testimony. And this would be scheduled between the attorney for the mortgage company or the bank, whoever wrote the mortgage, and the party who's living in there. And that's largely what's going on. There may be some motion practice that goes on during that time. One of the things may be that the mortgagor may be trying to strike the answer. They may find it insufficient. The judge would have to make a ruling on that. They may, after engaging in some of the information exchange, ask the judge to grant summary judgment, where in effect the standard is, we've stipulated these are the facts in the case. Judge, here's also the rule. Here's also the law that is relevant to these facts. Can you make a ruling based upon the facts as they're stipulated and the law? And oftentimes a case will end there. If we're unable to resolve a case that way, what we will do is then list a case for trial. And it would be a regular Superior Court trial where you would have, typically these are non-jury trials, I will say, but they would be before the general equity judge. I'll note as an aside that we're a little bit in a transitional period right now as we're moving the foreclosure docket from one judge to another. Judge Mark Sanson had been doing this. He is our presiding general equity judge. He's moving over into a different court, segueing into drug court, and consequently, Judge Mark Cimino is going to be taking over that docket as of the beginning of April. As a practical matter, that's a little different because Judge Sanson sits in Mays Landing, in the Mays Landing courthouse, and Judge Cimino sits in the Atlantic City courthouse. It does appear that we're going to be having hearings in Atlantic City, although we'll be able to take any kind of emergent filings in either place. As noted before, most in practice, the vast majority of papers that are going to be filed would be done electronically or to the Superior Court Clerk's office. There are two notable exceptions, and those are ones that are emergent applications. As noted, there was the motion to stay the sheriff's sale after the two adjournments. That can be done and can be filed. Unfortunately, they seem to typically be filed on the eve of the sale, which creates difficulty all around because quite frankly, for what I have to do is I have to find an available judge, a judge who's not in trial, which doesn't happen that often. So there may be some sitting around and wait period if you bring it in at the last minute. If it's done with a day or two notice, we can give you a time and minimize the wait time. Also, the other emergent applications could be to stay the actual eviction itself. And I would also note the same thing, is that if it's 11th hour, I regret that you may have to sit around for a little while until I find a judge that's available to do it. If you give us a little time, we're a little bit able to set up a time, set up a hearing and such. So generally, that's what we do. We get to the point where the issues are resolved, either through the motion practice of the two things that I mentioned earlier, or eventually by trial. Trials are, frankly, rather rare in foreclosure. Usually the issues can get flashed out during the discovery period, and there's enough to resolve it one way or another. There's one other thing that I really do need to note that the vicinage does have a strong hand in. As was noted earlier, there is a mediation program in foreclosures that can be requested within 60 days of service or soon after. If you've filed an answer, it can be done after an answer. The mediation will take place usually pretty quickly. We try to get it within about 45 days after the request in there. One of the reasons that there is a bit of a gap is in order to participate, there are certain forms that need to be complete, including a rather extensive financial disclosure form, where in order for the mediator to try to do their magic, and in order for the bank or the mortgage company to make frankly, a business decision, they would need to know what the lender's assets are, what their income is, how much is due on various bills and such, and it's a pretty extensive thing. We try to make sure that the information is as complete as possible before having the actual mediation session. Past practices told us that if people come in with incomplete information, there's really not much chance of the mediation to be successful. We're always interested in having mediation to be successful, always, always, always. There are a number of resolutions to foreclosures that can be discussed at that point. You know, everything from cash for keys, where they may pay the mortgagee a certain amount of dollars in order to vacate by a certain day. They may forgive certain arrearages, monies that are due and owing in order to vacate, and that sort of thing. But that's kind of what we do. And again, trying to get to the point where we're trying to resolve the underlying dispute that's going on there as expeditiously and as appropriately and well as we possibly can. When we do that, that's when we transfer it back to the Superior Court Clerk's office, and then we're done.
Just one quick thing to add. With respect to the forms associated with mediation, if you go onto our website, in addition to the actual application form for mediation, you will find another form which actually lists and identifies all the forms that you would need to put together in order to have a complete packet to participate in mediation. So they are identified for you. You're correct, it is an extensive packet, but you don't have to guess as to what you're going to need to provide. We'll tell you what you need to provide. So that information is also available on the court's website under the self-help packets.
It's quite comprehensive and really, really well done. There's, everything that you potentially would need is pretty much there. I don't think that there's much that you would have to make up in terms of legal pleadings, because most of the forms are already in existence there. So. All right, man.
My turn. I'm Mitchell Moskovitz. I'm the Senior Consumer Attorney at South Jersey Legal Services. My office is in Atlantic City. Tell you a little bit about who we are. We are a law firm in, I believe, I'll count the counties. We are in Atlantic, Burlington, Camden, Cape May, Cumberland, Salem, Gloucester, Monmouth, and Ocean County. Our services are free. So if you are a homeowner facing foreclosure and you're looking for legal services, you might be able to meet with me about your case. And my job is to help people who want to save their home try to figure out a way that they can indeed save their home. It may be defense to a foreclosure action. It may be a Chapter 13 bankruptcy. We do not offer representation in every case, but we qualify for our services. You can certainly get advice with regard to your matter. I want to talk briefly about the issue of defense of a foreclosure matter, because although there is a right to file an answer to contest a foreclosure matter, that doesn't necessarily mean that a defendant in a matter should file an answer. You file an answer if you have a reason why the bank can't go forward and foreclose on your property. Examples of things that are commonly not defenses: I fell on hard times, I can't afford to pay my mortgage anymore, you know, maybe the judge at the court will cut me a break and rework my payments. Not a defense, okay? What may be a defense to foreclosure? And these are the reasons why you would file an answer. Maybe there was, by example, fraud involved in the mortgage. Maybe when you went to take your mortgage, you were promised an interest rate of 3.5%. You sat down and they put the papers in front of you, and 6.5%, and they said, take it or leave it. You signed it. But for the fact that it was 6.5% instead of 3.5%, you fell behind. I'm not saying that's a winner, that's a loser, or a loser. But what I'm suggesting is that that's a reason why they may not be able to foreclose. Some of you may have heard it's been an issue over the past couple of years standing, which is whether or not the plaintiff has a right to foreclose. Generally, the plaintiff, the foreclosing party, would need to possess the note at the time of the filing of the foreclosure complaint, so that they are the true party in right to foreclose. Just presenting these as examples, but if you're trying to save your home and you don't have a defense, then I suggest that you consider some other options instead of simply filing an answer to a foreclosure case. One of the things that was mentioned was the foreclosure mediation program. Again, I'll reiterate, the foreclosure mediation program, if you qualify for it, is a great way to try to save your home. You have to apply for the foreclosure mediation within 60 days of service of the complaint, and you get to meet with a real live person instead of what happens over the phone, which is a lot of telephone calls and a lot of transfers, and gee, I didn't get to the person I needed, and they lost my material, or whatever it may be. You get a real live person, and you get a mediator whose job it is to try to bring the parties together to resolve the matter. My suggestion is, if you go to foreclosure mediation, go with money, because you're much more likely to catch the attention of the lender if you have something to come up with. In fact, if you're looking to save your home, whether you are filing an answer to a foreclosure complaint, whether you are hoping to resolve directly through a workout with the lender. By the way, you should, if you're trying to save your home, delve into all options available. Whether you're planning on filing a 13, or for that matter, whether you believe you have a defense and file an answer. I advise to start squirreling away money, because in most cases, the mortgage is not going to go away. It's going to be a matter of some resolution where you're going to resume mortgage payments, and you're in a much better bargaining position if you come to mediation, or if you're trying to work out through a defense of the matter, if you have 5 or 6 months worth of mortgage payments. It shows good faith, it shows that you've been able to put the money together, and it's much more likely to catch the lender's attention. Basically, the grounds to foreclose are really simple. The right to foreclose, what does the foreclosing party need to really show? There was an execution of the note and mortgage, that it was recorded, and that there was non-payment. Briefly, I'll describe the two components that we were speaking about before, that have been alluded to before, the note and the mortgage. Generally, these are signed, executed at the same time. A note is an IOU. It says, I'm borrowing money. You're usually borrowing the money to buy the property or refinance the property. And what you do is you sign the note and say, I promise to pay back at X% over some period of time. And the mortgage says, if I default on the note, I am pledging as collateral my interest in the property. Now, you'll have situations where a husband and wife who will own the property together as tenants by the entirety, or which is usually the way a husband and wife own the property, where one party may sign the note, but both parties sign the mortgage. What does that mean? It means, let's say that the wife signs the note, she signs the mortgage, and she says, I pledge my interest if I default on the note. And the husband signs the mortgage and says, I pledge my interest if my wife defaults on the note. And that's really, a default is really what is going to allow the foreclosing party to begin the proceedings. Now, at least 30 days before the foreclosure complaint is filed, under the law, a homeowner must be served with a notice of intent to foreclose. The notice of intent to foreclose, which is part of the New Jersey Fair Foreclosure Act, allows the homeowner to catch up on the missed payments without having to pay attorney's fees or any other costs involved in a lump sum within 30 days. If those monies are not paid, at that point, the lender can go forward and go forward with the foreclosure action. If a party is not properly served with a notice of intent to foreclose, then there had been a case where if the notice of intent to foreclose was improper, it was grounds to dismiss the foreclosure complaint. More recent court rulings have changed that. It may allow, I would say, as a practical matter, in most cases, if a party was not properly served with the notice of intent to foreclose, it would allow him the same rights, which would be for him or her to catch up on the missed payments in a lump sum without paying the attorney's fees. By the way, a homeowner can catch up on the missed payments and save their house if they're able to raise the money or get the money any time before the entry of final judgment. Final judgment happens a good bit down the line. From the time the complaint is filed to the time of final judgment, I guess you guys could probably tell me more, but I would be surprised if it's less than 6 months.
Probably a year to 18 months.
Probably a year to 18 months from the time the case is filed to entry of final judgment. So up until the time of final judgment, if you get an inheritance, or I'm not suggesting you play the lottery, but if you play the lottery and get a bunch of money, you don't have to pay off the whole amount that's owed. You have the unqualified right to catch up on the missed payments up until the time of entry of final judgment. Once final judgment enters, then if you want to save the house and the lender does not want to negotiate with you, you have to pay off the entire judgment. I want to talk a little bit about Chapter 13, bankruptcy, because let's assume that you don't have a means to catch up in a lump sum on the missed payments, and let's assume that you don't have a defense to the case. Where should your efforts go? In my opinion, number one, you should request mediation, has been discussed here. Number two, you should certainly talk to a HUD housing counselor. There are some great programs with HUD housing counselor. I think there's one program now, the Home Savers Program, which if you qualify, offers a significant amount of money, $50,000 or $55,000, something like that. I'm not exactly sure. Up to $49,000. So HUD housing counselors, Google HUD certified housing counselors. I can't recommend any particular ones, but they're really excellent. They know what they're doing, and they can help you work with the mortgage company. Keep in mind that even once your property is in foreclosure, there's no reason why the lender can't attempt to modify the loan, work out the matter, which is what you're attempting to do in mediation. That's what we're talking about in mediation. The parties getting together, and maybe they take the missed payments, put it on the back of the loan, recapitalize it at a larger principal, reduce the interest rate. These are the things that happen in a workout or in foreclosure mediation. So those are things that you should pursue. Mediation, HUD housing counselor, review the matter if there's a defense, but if there's no defense, my suggestion is put your efforts other places. Let me get back to the idea of Chapter 13 bankruptcy. Chapter 13 bankruptcy, unlike a straight Chapter 7 bankruptcy, allows you to provide a plan to the bankruptcy court to try to save your house. A Chapter 13 bankruptcy can be filed for purposes of saving your house anytime before the property goes to sheriff's sale. Once the property goes to sheriff's sale, it's too late. But that's way down the line. Judgment takes 12 to 18 months. Even after the judgment, as was discussed, the writ of execution is going to issue. They're going to schedule the sheriff's sale. You're going to go to Sheriff Bales and ask for your first 2-week adjournment. You're going to get your second 2-week adjournment, and maybe you'll come into my office the day before the sheriff's sale. Hopefully you'll come in months and months and months before. but you'll come in if you came in at the 0 hour and said, I want to file a Chapter 13, and the sheriff's sale is scheduled for 12 noon on a Thursday, still scheduled on Thursdays? And the Chapter 13 bankruptcy is filed at 11 o'clock on Thursday, it freezes and stops the foreclosure from going forward. Now, I am not suggesting that anybody file a Chapter 13 bankruptcy on the eve of a foreclosure sale.
It happens.
It happens. But what I want you to know is the deadline that it can be done. It can be done before the property goes into foreclosure. It can be done when you receive the notice of intent to foreclose. It can be done when you first get served with a complaint. It can be done after you default on the complaint after 35 days. It can be done before the notice to enter final judgment is entered. It can be done after final judgment is entered. It cannot be filed after the sheriff's sale. It's too late. Now, this is the general framework of how a Chapter 13 works. Take your missed payments, spread them out over 60 months, and stay current on your mortgage payments going forward. So let's say, for sake of argument, your mortgage payments were $1,000 a month, and you file a Chapter 13 at a time when you're $12,000 behind on your mortgage payments, and you're in foreclosure, or foreclosure is being threatened. You file, it's today, March 18th? File today, March 18th.
16. You're missing Patrick's
16.
Day. You can't miss St. Patrick's Day.
Okay. You wait until Friday and you file on St. Patrick's Day. April 1st, you resume making your $1,000 mortgage payment directly to the mortgage company. You take the $12,000 of missed payments, you spread them out over 60 months, which is approximately $200 a month. You send $1,000 to the mortgage company, you send $200 a month to a Chapter 13 trustee for 60 months. At the end of 5 years, you have cured your arrears, you have reinstated your mortgage, and you get to keep your property. Now, there's other things that you may also be able to do in a Chapter 13, depending on the amount of equity in the property, which means the difference between the value of the property and the amount of the mortgage. You may be able to get rid of your credit card debt at the same time that you're curing your mortgage arrears. You may be able to modify your car payment at the same time that you're catching up on your mortgage arrears. All these are possibilities. But the advantage of filing the bankruptcy is it stops the foreclosure proceedings. There's a couple of basic tenets of bankruptcy. One is fresh start, you're trying to start over, and the other is breathing room, stopping the process. So Chapter 13 is definitely something to consider. Now, sometimes it's not going to be possible to stay current on your mortgage going forward and catch up on the missed payments over 5 years. Again, if you could stay current on the mortgage, you might not be in this position to begin with. So under Chapter 13, you don't have, traditionally, you don't have the same advantage that you may have under a loan modification program. Let's say your mortgage, under this example, was $1,000 a month. Well, under a loan modification program, you might work out a deal where you don't have to pay back any of your arrears, and you're able to reduce through a lower interest rate or stretching out the term to reduce your mortgage payments per month to $700 or $800 a month, by example. Chapter 13 more recently has what they call a loss mitigation program, which is a program similar to the foreclosure mediation program or similar to an attempted workout directly with the lender. I see it oftentimes as a, legitimate last-ditch effort. Let's say you've gone through foreclosure mediation and that has been unsuccessful, because in mediation, you have to understand, the mediator cannot impose on the parties any terms. Mediation only works if the parties get together and they agree that this is the workout that they want to do. A typical Chapter 13, where you stay current on your mortgage payments going forward and catch up on your missed payments over time, that you have the unqualified right to impose upon, I should say, all else being equal. Let me put it this way. The lender can't say, oh, I oppose a cure and reinstate. If the cure is proper, if it can be afforded, you have the right to do that in Chapter 13. Okay? Mediation, the parties got to get together. A cure and reinstate under Chapter 13, whether the lender wants to do it or not, if you can afford it, you can do it through a Chapter 13 plan. But Chapter 13 also now has a loss mitigation program, like I said, which is similar to a workout program or to the foreclosure mediation program. So let's say you can't afford a cure and reinstate through a Chapter 13. You've gone through foreclosure mediation. You've talked to a HUD housing counselor. All of that unsuccessful. You've attempted to work out directly with your lender, also unsuccessful. You're getting close to a sheriff's sale. You might want to file a Chapter 13 to take one more shot at loss mitigation or a workout with your lender. Even though it hasn't prevailed before, maybe you'll have more luck this time. Maybe the lender's standards for a workout have changed. But the advantage, again, of filing a Chapter 13 is the automatic stay, which stops the foreclosure process from going forward. So those are some thoughts on saving your house. Let me also put forth some thoughts in not saving your house. We've seen the real estate market drastically decline in Atlantic County. One of the things that you might want to consider before you go to great lengths of trying to save your house is, what are you really saving? If your house is worth $39,000 and you owe $120,000 on your mortgage, and the fair rental value of your house is $800, and a workout with your lender is going to be $1,500, does it make any sense? You can't sell your house because you don't have enough money to pay off the lien. You're effectively renting your house. There's no equity in there, and you're paying much more than fair market value. And because the foreclosure process takes a long time to go through, it's still your home, still your house. It's your house, I would say, up until the sheriff's sale, but it's actually your house until 10 days after the sheriff's sale, as the sheriff will go over, because that's when the deed gets delivered to the buyer at the sheriff's sale. So, if you're in the early stages of foreclosure and there's no defense and you're underwater on your mortgage, it may make sense to try to put away, save some money, and look for other alternatives. I just want to mention one more thing. People have said to me, well, gee, I owe $100,000 on the house, and house is only worth $40,000. Isn't the mortgage company going to come after me for the difference between what I owe and what it sells for, or what it's worth? The answer is that they can, and they rarely do. And there's a reason why, after a sheriff's sale, it is unlikely that the mortgage company will come after the former owner for a deficiency. And that's because, well, first of all, deficiency actions must be brought within 3 months of the sheriff's sale. Okay? So if the lender wants to sue you for their loss because the property's gone down in value and you owe so much more, it must be brought in 3 months. A deficiency action is based on fair market value controls. So if the top bid at the sheriff's sale is $100, the property's worth $39,000, there's $100,000 owed on the mortgage, market value controls $39,000, not the few $100s that it sold for back to the lender. But the reason why a deficiency action is, in my opinion, rarely brought is that it reopens the foreclosure and sale of the premises. And the person against whom the judgment has been recovered may redeem the property by paying the full amount of money for which the judgment in foreclosure was granted, with interest costs and reasonable expenses. Which means a bank, who most often will be the buyer at the sheriff's sale, they've completed it, they have title. If they seek a deficiency action against me, if I get financing, I can come back and pay off that judgment. So I believe that that's a risk that lenders don't want to take. Once the property is sold at a sheriff's sale, that is a conclusion for them. Good marketable title is transferred because all of the liens, encumbrances on the property are foreclosed. And so, in my opinion, that's one reason. I would imagine the primary reason why we don't see deficiency actions. And that's really it. Again, as I said, I've got information up here on South Jersey Legal Services. I've got my card, I've got the intake number. If you think that you might qualify for our services, feel free to take the information. And good luck to all of you, and I wish you all the best.
Okay, hi. My name is Sheriff Frank Ballas. So I guess looking around the room, you would never know that Atlantic County has a foreclosure problem with the amount of empty seats as we have in here, correct? Mm-hmm. And, you know, one of the things that we see is a lot of times when foreclosure process just gets in its infancy, when you first start getting them late notices from the bank, that's the mail that doesn't get open. That's the one we just put over here and eventually goes out in the recycle bin. And more notices continue to come, then you get the notices from the court, then it seems like we don't really see the attention of the person who's being foreclosed on until our officers show up about 30 or so days prior to the sheriff's sale date, and they either hand you or you come home and you find something posted on your door that says contact the sheriff's office, this is the date of your sheriff's sale, and it gives you all the particulars, and basically you've then been given notice that on a certain date your property is going to be sold at sheriff's sale. We don't know who the occupant is of the house. It could be the borrower. It could be a renter that's in there. We see a lot of times that people know that their home is basically in foreclosure, and sometimes that process could take 9-10 years. We've seen some that we got the writ from the courts in 2016, and we sold the property in 2016. So the process is moving a lot quicker. Back in 2010, there basically was a foreclosure moratorium. So for about a year, the entire foreclosure process was completely stopped because you probably saw it in the news and everything else, where the court system, Judge Grant felt as though that the process was being basically rubber stamped and being pushed through. So the process is very detailed now, and it's a very good process. Again, like I said, it was about a year for that process to then all the rules be rewritten. So basically what happens is we're I guess you would call the last stop on the foreclosure train. Once we get it, we basically, like I said, we'll post your property and let you know the date. Then we have to advertise that. Every Monday you'll see in the sports section. I was a really good baseball and soccer player, sports player when I was growing up. I had no idea my name would be posted so many times in the sports section. Every Monday there's about 17 pages worth. It's crazy.
Unbelievable.
For 4 consecutive weeks, we have to put that notice in there, which basically gives you all the details of the property, the location, the lot and block, the amount that's owed, any liens that are listed on the property, all the particulars that we end up getting through the court action. And eventually, like we said, the property goes to sheriff's sale. A lot of times we do get these stays where the defendant, which is basically the borrower, will come in. We allow them, by court order, we allow them up to 2 adjournments. So the first adjournment they get costs them $28, and then the second adjournment is free. The plaintiff, which is the lender, they can postpone it as many times as they want. Some properties are postponed 15, 20 different times, months, years at a time, by the plaintiff. And like I said, the defendant only gets 2. The defendant, like you heard earlier, once they've exhausted both of their adjournments, they can and a lot of times do go up to the courts to seek a stay. The stay doesn't happen very often, although what does happen quite often is the judge will grant a month, 2 months, sometimes 3 and 4 months, basically that no eviction process can take place, but the sheriff's sale will still go forward. And we hear a lot of the horror stories, just like the judge hears a lot of the horror stories. I've talked with Judge Sanson many times, and he tells me that he thought being a family court judge and hearing all the pleas back and forth with custody and divorce and everything else, he thought that was horrible. Then being a criminal court judge, he says until coming and sitting as an equity judge and seeing the people that he's going to have to put out of their house, or say, yeah, you can stay for a little bit longer, that's the most heart-wrenching of anything. And same with our officers. We're doing basically every day, we're doing 2 to 3 evictions every single day. And they're just properties. We don't do landlord-tenant evictions. They're done by a sergeant warrant of Superior Courts. This is just properties that have been foreclosed on. And it's tough. A lot of times you're basically putting somebody out of a house that's could be handicapped. There was basically a priest from Corbin City that basically used their property as a church for many, many years. The place was completely paid off. And once he basically got so old, he ended up having to stop holding services there. So then it went from being a non-taxable property to a taxable property. So after the taxes, a lot of people can afford their mortgage, but they can't afford the taxes. When you look at an average household is paying about $500 a month in taxes. They can afford paying the $500, $600, $700 it costs for the principal and interest. Then when you tack that extra $500 on, a lot of times they can't afford that. So this guy ended up getting a reverse mortgage, and things went bad, and we ended up having to sell his property at sheriff's sale, and then eventually the bank wanted the property back, and we ended up having to evict him. This guy was close to 90 years old, and there's situations that happen. So we try to do whatever we can do to help people stay in their homes, because we're hearing these stories all the time. Every year we have a economic and energy assistance expo where we bring about 25 to 30 different vendors in, and basically we'll help you with everything from being able to save your home. Stephanie from Clarify, she's sitting over there, raise your hand. Stephanie, we refer a lot of people to Stephanie. We refer a lot of people to Russell Graves. He's a consumer credit and budget counseling. They're HUD certified counselors. If you're in this foreclosure situation and you see different advertisements or whatever the case may be, and you call this person up and they say, yeah, no problem, come in, it's going to cost you $2,500 or $5,000 or whatever, and I'm going to be able to save your home. If they're telling you it's going to cost you money for them to work with you to save your home and counsel you, just hang the phone up or whatever, end that conversation, get away from them, get as far away from them as possible. We refer a lot of people to Mitch and to his partner, Jim McLean, and we've had them out when we do sheriff sale seminars and everything else. This year, our Economic and Energy Assistance Expo is next Thursday, March 23rd at St. Gianna's Church. It's in the church hall. in Northfield, which is the old St. Bernadette's right across from McDonald's. And we've been able to, right on the spot, be able to get people enrolled in the different programs. You heard about the New Jersey Home Savers Program, there's a New Jersey Homekeepers Program. Get them right then and there and get them signed up and get them applied. There's up to $48,000 that they can, $49,000 that they can receive to help pay back their mortgage or taxes or whatever the case may be. They can take it all in one lump sum payment to pay that off, or they can take it if they can't afford because their salaries have just been reduced for whatever reason. They can take X amount a month and put that towards their rears or whatever the case may be to make that work. And you would have to talk to Stephanie. We don't do that at our office. We're now dealing with a new company. Although they're not really new, they've been around since about 2009, but they've been in other states. New Jersey Housing and Mortgage Finance, they made the contact with me for this company, and basically it's called the Sun Initiative through Boston Community Capital. They've basically since late 2009 in the states of Massachusetts, Illinois, Maryland, and Rhode Island, they've helped over 600 families, spent over $100 million and saved 460 properties. And of course, now they want to make a footprint here in Atlantic County and in New Jersey. And a lot of times you hear that if the house has been sold at sheriff's sale, you're basically doomed. You're just waiting for us to come and put you out. Basically, if you qualify with them, and all you basically have to have is an income that would support paying whatever the mortgage is, they will negotiate with the lender, the bank, whoever the person is that you had your mortgage with, and they will attempt to, and in most cases, buy that property at the distressed sale price. Then they will then mortgage that property back to you. I think they mark it up like 20%, 20 or 25, somewhere around there, from that distressed sale price. And they're not worried about what your credit is or anything else. They know that your credit is already going to be bad because that's why your house is being foreclosed on. The worst thing is a lot of times we have people that come in and say, well, what can you do for us? You're going to sell my house tomorrow, or you're selling my house today at 12 noon. What can you do for us? How can you save my house? And we say, well, we'll refer to these companies. Do you have anything saved? No, I don't have a penny saved. And when was the last time you had a mortgage payment? No, about 7 years ago. A lot of people will just, I guess it's kind of a good thing. You're staying in the property. You're not paying any rent. But if you're in that situation, make sure whatever you're doing, you're putting some money away, because eventually there's going to be a position where you may be able to get some help, but you also have to have some funding too. And if you're behind and have nothing and have no way of getting anything, there really isn't a program that I know of that can help you. The New Jersey Homekeeper Program is a great program and does help a lot of people, and there's a lot of money that is still left in that program, but people have to take that initiative to make it happen. We've also had people that have had their houses posted, whether they're a renter or whether they're the borrower, and they've come to sheriff's sales weeks prior to their home going for sheriff's sale, and they've met with some of the investors there, and a lot of times the bank's upset price, and the upset price is basically the amount that the bank will bid up to. So that's the amount that they're willing to accept. A lot of times their upset price is a lot lower than what the actual decree is. And they've met with, in a few cases, they've met with the investors that are there to buy these properties and try and flip them and sell them, and would say, well, if it's, I know I can get up to X amount of dollars. If it goes for that, can you buy the property and then, either hold the mortgage or, sell it back to me? And what they'll do is they'll buy it, they'll mark it up a little bit, make some money because it's going to be quick, and somehow you can get your property back. It's not really recommended for anyone to come in there and bid on their own property, because what can then end up happening is, which Mitch talked about a little bit, that whatever that difference is, then that bank could come back to you and say, okay, now, you bid what we were asking for it, but now it's going back into your name, you still owe us X amount of dollars. So we never recommend anybody to go in there and bid on their own property. If you are coming to sheriff's sale to bid, you have to have 20% down in cash, certified check, or money order. And you have to have the full 20% of whatever you're planning to bid. And within 30 days, you have to have the balance. Same thing, cash, certified check, or money order. A lot of times, will people come there and doesn't matter if they're bringing $2,000 or $100,000 in cash. It's not like the bank where you have to verify where you got that money from. The money is that's your deposit. We do get your deed to you within right after the 10th day. So usually it's about the 12th or 13th day because of the weekend. And basically what happens is you can pay it off right then and there. From that date forward, from like the 12th day on, you start paying a percent interest charge on that money. So, but you do have up to 30 days. Basically what you're doing is when you come and you bid on a house at sheriff's sale, you're buying, unless you already know about the property, you're basically buying sticks, what do they call it, sticks, bricks, and dirt. So you're not allowed to go into the property, you're not allowed to go onto the property and look at it. Now, do people, drive by and if nobody's around, look in the windows and stuff like that? Probably. We don't want to know about that, but probably. But I can tell you that we had a gentleman that bought a property in Atlantic City, and a lot of times what they'll do is they look the property up on either their iPad or their computer or their phone or whatever, and you can get the pictures of the property and all that. And this guy bought a duplex in Atlantic City on a certain street in Atlantic City, and it was a great deal. He got it for $7,000, right, a duplex. So once he paid it off, or actually after he gave his deposit, he went to Atlantic City to look at the property, and found out it wasn't anything but a dirt lot. The duplex that was there was gone. Somebody tore it down. So, like I said, if you're coming, make sure you're doing your research. Any liens that are attached to their property, we basically tell you what we know, what we get from the attorneys representing the lenders, and the lender will always have somebody there to basically update, to say what they know as far as the taxes and what they know as far as any additional liens and stuff like that. But you still have to do your own research because there still could be something out there. A lot of times there's the original mortgage, there's a second, there's a third, there's a fourth. Basically the bid takes care, as long as they're in that in the writ, all them mortgages, first, second, third, they all go with the bid. So in other words, if the first mortgage is $100,000 and then there's another 20 and another 30 and another 40, you're not responsible for that other 20, 30, 40. That all goes with whatever your bid is. We average about 35 sheriff's sales every week, every Thursday. We start out with about 110, 112, and then through postponements and adjournments, it gets down to about 30, 35. And the range of prices is, we've sold properties for as low as $100 for an entire house. And we've sold properties for, I think the highest one we sold in Longport was a little over $3 million. So it's a very interesting process. If you're in foreclosure, if you're here because you're in foreclosure, I would recommend coming to this expo if you have the availability. If you don't, make sure you talk to Stephanie today. She can give you some good information and give you information on the Sun Initiative and give you the phone number for that. Sun Initiative, because I only have the one folder right now. If you want to write down their number, it's 855-604-HOME, which is 4663. So 855-604-4663. Now, like I said, they would rather while you're early on in the process to get with them, because I ask how late is too late. And they've actually, in some cases, even after the property has gone to sheriff's sale and sold, they've been able to work a deal with the lender. And as long as it isn't sold to a third-party buyer, that you always take that chance. We do sell a lot to third-party buyers. they've been able to negotiate with the lender, buy that property, and then resell it back. When I first learned about this program, about 4 days before I learned about this program, I got a call from the chief of police in the city of Pleasantville, and he asked me if there was anything we can do for this one lady, and we were going to meet in his office at 6 o'clock one night before another meeting. And this is a lady who, about a year and a half ago, her son was about 20 years old, standing on someone's porch, and a car drove up and shot him 8 times and killed him. She was her only son. It ended up being a mistaken identity type thing, but either way, the kid's dead, and no one's been caught on this case yet. The woman spent about $30,000 on funeral expenses, got behind on her mortgage payments, of course, ended up being out of work for a little over 6 months because she just couldn't wrap her head around losing her only child. And again, behind in mortgage payments. Her husband is a disabled veteran. And so she ended up going to an attorney at a local law firm. She had about $12,000 that was still, saved up. And basically what happened there is this guy was going to get her out of foreclosure and everything was going to be fine. And so he got their money and left that firm and nothing. So I said, well, when you go on the sheriff's sale? She said, next week. Have you used your adjournments? 1. So we got her through the next adjournment. She ended up, the next one right before her sheriff's sale, she went to the judge, and the judge basically said, we're not going to stay at the sheriff's sale. Your property is going to be sold, which was the next day, Thursday. And but I will let you stay in the house. And this is their home. They've been in 20 years, and there's only $80,000 owed on the house. I will let you stay in the house for 4 months, and this is a date that you'd have to be out by, and no eviction procedure could go forth then. And we did get her hooked up with this program, and she started the program. So I found out whereabouts she was with that, and it looks like it's going to work out for her. But the house was going to be sold. It was 2 weeks ago. So luckily, I looked up her property and found out that the lender was New Jersey Housing and Mortgage Finance. Thank God. So I called them and actually got them to postpone it, even though their attorney told the judge they wouldn't postpone it. Talked to the people that I know there and that run the program, and they postponed it until the 30th of this month. So it looks like she will either get this program or get the New Jersey Homekeepers program with the $48,000. She's only behind $40,000, and she will save her home. So when we say what's too late, we never know what's too late. But what is too late is once it's sold, and you as, and I'm saying you, anyone as a person that's being foreclosed on doesn't come forward and say, well, what can you do to help me? Ignoring it's never going to go away. The only thing that's going to go away is the property. And eventually, you'll end up being put out of the property. And a lot of people get mad, because, that bad bank, they took my house away, and, although they're losing it, they signed that commitment with you, with the homeowner that you were going to pay, and now whatever happened in your life, something changed, but keep them posted. And next thing you know, what happens is once it's going for sheriff's sale and you got to get out, people go in and they rip the floors up, they put cement in the toilets, they just trash the house, which is just not right. But don't ignore it. Come to us. Go to Clarify. We can direct. Like I said, we refer to different people. We'd be in the middle of a sheriff's sale, and we get the phone call from the court. Well, this one's going to be seen by the judge, and it's after 12 o'clock, and it could be we'll put that file as the very end, and sometimes quarter after 12, 12:30, quarter to 1. As long as we're still doing sheriff's sales, next thing you know, we have one of our clerks walk in and say, the court's just called down. This one's got to stay, or this one just filed for bankruptcy, or whatever the case may be, and the case is pulled. But again, if you do nothing, the property's going to go away. It's going to be sold. So please just ask the questions. There's never a dumb question when it comes to foreclosure.
Thank you.
We're gonna
Excellent
hang around for a few
information.
minutes.
And you'll be around
We'll hang
for
around for
questions.
yeah, to anybody
Good.
who wants to
Thank you.
ask some questions.